legally speaking, with me, Tarun Nangia. Today we discuss a very, very important judgment of the Supreme Court. This judgment is about modification of arbitral awards. Can it be done under certain circumstances? What the judgment is? Let me first say that five judges of the Supreme Court, Justice K.V. Viswanathan, Justice Bhushan Gawai, Chief Justice of India, Justice Sanjeev Khanna, Justice Sanjay Kumar, and Justice A.G. Masih. They have reflected on this. Of course, we all by now know that Justice K.V. Viswanathan has also authored his own judgment, his own opinion here. And what is that? Of course, we will discuss on the show. What are the implications of this judgment for the arbitration landscape in India is what we actually want to understand for the industry, for the general counsels, for the investors, that what after this judgment. This is what we're going to discuss, whether to what extent the court have the powers to modify or sever the awards. That is what everybody wants to know after going through the whole process and reaching the Supreme Court. Can the award be modified? And if so, then what happens to the industry and the investments? Let us understand this. Let me welcome Justice Arjun Kumar Sikri on the show, sir. Thank you for your time. As you all know, he's India's leading arbitrator. He's also a judge of the Singapore International Commercial Court. He's also served as a judge of the Supreme Court and the Chief Justice of the Delhi High Court and the Punjab and Haryana High Court. But now his identity is that of one of India's foremost arbitrators. Good to see you, sir, and thank you for your time. I have with me Senior Advocate Arvind Nair, who practices at the Delhi High Court, Supreme Court, and other forums. We have with us Tahira Karanjawala, who is associated with Karanjawala and Company. She's a partner there, one of India's leading law firms. And of course, this involves a lot of arbitration and a lot of challenge to arbitrations in Supreme Court, where she primarily is day to day. Good to see you, Tahira. Shortly we'll have Advocate Karthik Seth joining us, followed by Senior Advocate Percival Bilimoria. But let's start the show. So, in the first 3 to 4 minutes, what crossed your mind when you first read this judgment, and what are the takeaways for the economy and the whole landscape in India, and also for the investors?
You see, if I may start from the beginning, in the sense that the ecosystem of arbitration and how the entire scheme is under the Arbitration and Conciliation Act 1996, or as the arbitration is perceived, I mean, all over. And actually, it's an alternate dispute resolution mechanism which is away from the courts. So the parties agree that our dispute will be decided by the arbitrators. It may be sole arbitrator, it may be panel of the arbitrators, and that what we call is the party autonomy, that the parties decide their arbitrators and who shall decide. And the legal position is also this, that the arbitrators, when, of course, they will be deciding the cases on the basis, suppose there is a commercial dispute and there is a contract which was entered into between the parties, and one party is blaming the other that it has committed breach, because of which I have a claim against the other party, and there may be counterclaims, etc. also. But then they leave it to the arbitral tribunal to decide that. And the law is that the arbitral tribunal, it's the best judge of or the arbiter, insofar as not only the facts are concerned, if disputed facts, how these are to be determined, and even on the interpretation of the contract, etc. clauses, the way they interpret. And therefore, under the Arbitration and Conciliation Act, any award passed is the final. And under this 1996 Act, it is even a decree of the court, like it is decree of the court, which becomes enforceable and it can be straight away executed. Of course, not that award cannot be challenged. At the same time, we have provisions like Section 34, which affords very, very limited grounds on which the award can be challenged. And so we need not go into those grounds in detail. But then Section 34 says that if any of the grounds is satisfied, the court has the power to set aside that award. That is the expression used. And otherwise, the naturally court will, if the court rejects the challenge to the award court and it attains finality, then naturally it becomes enforceable straight away. So that's the mechanism. And as I'm again repeating that the challenge is very limited. Unlike the court system, where suppose I file a suit in the court and the court has decided that, said whether it is trial court or the say Delhi High Court, which has the original power, it has decided. And but our Code of Civil Procedure provides for appeal against that under Section 96 and read with Order 41 of the CPC, appeal can be filed. But the first appeal is like the first appellate court has power to see everything, whether the lower court decided rightly or wrongly, whether it is facts or a finding of facts, whether it is findings on law, etc., and decision on law, etc. Everything can be revisited and gone to it again. Second appeal is also there, but second appeal is only on the questions of law. So this is the basic difference between the arbitration regime and the court regime. Here, the challenge is not on merits at all. So challenge is principles, natural justice not followed. Award is against principle. Against the public policy, etc. So those are very, very limited grounds and not on the merits. Now, in sometime it's still so therefore court is not sitting as when the award comes and in the Section 34, court is not sitting as an appellate authority to see whether the decision is right or wrong. So in this scenario, the question comes that if the court feels that there is something wrong with the award, now whether the power is there and under Section 34 some ground is satisfied, power is there to set aside the award. So in that context, question arises whether instead of setting aside the award, because if the award is set aside, maybe matter would go back to, whether the same tribunal or parties may agree for another tribunal, it may be re-agitated. But whether instead of doing that, whether court itself has power to see if they see some minor error or some other error to modify itself. So if whether that power is there or not, so that was the issue which came up for consideration before this 5-judge bench, because there were some difference of opinions on that. And so therefore it came to the question, and one view was, which is now accepted by the majority 4 judges, is that no, to some extent, limited extent, it can be modified. And of course, there are some conditions which are to be satisfied, because there were 4 or 5, I think, questions of law which were framed and referred to the 5-judge bench. And it was whether the Section 34, 37 includes, when we say set aside, whether set aside means modification also, number one. And coupled with that, the related issue was that although modification is not stated, but the expression setting aside, whether it is large, when the power is larger power is there to set aside, it includes the lesser power to modify as well. So that was one way, and therefore they said that, okay, and another important thing is that part of the award which can be set aside, and on that there was already view that which can be severed and can be, it is severable from the rest of the award to that part. So to that limited extent, it can be modified, and it should be only for very, very limited aspects like payment of interest. Suppose interest is awarded by the arbitral tribunal at 16%, 18%, court wants to reduce it to 10% or 12% or something, sometime maybe about the cost, etc. also. So these aspects only can be tinkered with. So that was one view. The other view was, sorry, you cannot do that at all, because setting aside will not include modification. And therefore the view which was taken by one of the judgment in Hakeem's case, this view was taken that, look, in that case, if the court feels that there is something wrong, so that the opportunity be given to and send it back to the arbitral tribunal to rectify it. And because that power is not with the court, and the court had in that case interpreted Section 34 when it says set aside, that power of modification would amount to amending the provisions of the Act, Section 34, because it doesn't include modification, because it is sui generis and it can't include modification at all. And therefore, we can send it back. And in thereafter also, if the tribunal doesn't rectify that, then we have no option but to set it aside. But then we can't modify it ourselves. So that was the question. And here, Justice Viswanathan has accepted that view that we cannot do it, and Hakeem judgment that we cannot do it because Section 34 talks of set aside, and they have given their detailed reasons that when it talks of only setting aside, it cannot include modification, because in that case, you are making yourself as an appellate authority by, sorry, which is otherwise not permissible and which is an accepted position. But having said that, interesting thing is, what I feel is that although there is view, I mean, speaking for myself, I will agree with minority when it comes to the interpretation of that section, that Justice Viswanathan view that court may not have the power to modify. But having said that, what I would say is that even the majority, while doing so, has not given very wide powers of modification to itself or to, I mean, courts under Section 34 or 37 when it is appeal against 34, or under itself under Article 142 of the Constitution of India, because they have said that, again, in respect of interest, they have said it can be done. But fact remains, and it was that courts have been otherwise also, even earlier also, way back in 2007 in McDermott case, where the court said that we don't have power to modify, and even not in so many words, but almost that was the, take of that judgment. But still, interest they had reduced in that case also, they are tinkered with. So therefore, they said that these are the kind of 3 or 4 kinds of things they have laid down, which the courts have been doing even otherwise. So what I will feel is, that is what I feel. In the long run, it doesn't affect either way. And the judgment is that modification may be done to limited extent, which has been happening earlier also. Principally, I would say that power of modification, my view is, may not be there. It is difficult to trace that power under Section 34, but the majority went by that look, suppose it's a case of reduction of interest, because the primary objective of any arbitration is to quick decision of the case, and it should be cost effective. So for these small things, if we send the case back and then the case comes back, now not only it entails delay, but it would be, the parties will be incurring much extra cost as well. So why undertake that exercise? Why not do it itself? So this is, in a way, majority has carved out some practical aspects, I would say. So if we go legalistic of interpretation of Section 34, such a power may not be there. If you want to approach the issue from a practical point of view, so limited power, which is for modification, which the courts have carved out, may be a good idea, I will say.
Thank you for that opening comment. We'll have to see to what extent court uses its powers, be that reduction of interest, be that severing the award, because I think the key word here is discretion. If that discretion becomes too wide in the Supreme Court, then the arbitration process itself may be futile. So this is something which is a worry. I'll go to Advocate Tahira Karanjawala from Karanjawala and Company for her opening comment. Over to you, Tahira.
Thank you very much, Tarun. So I think this was a judgment that a lot of the bar as well as many litigants were waiting for. And it's actually, I think, an extremely important judgment from the point of view of arbitration and commerce in general. So I think what the majority has done is sought to, as Justice Sikri was absolutely rightly saying, they've taken a practical approach, keeping in mind the particularities and peculiarities of our Indian system. So one of the major themes of the majority judgment is that the hardship faced by litigants should be reduced. So they have elaborated as to how in under our arbitration scheme, there's an arbitration, then you have a challenge under Section 34, and then you have a challenge under Section 37, and then there is a special leave petition under Article 136. So you have four levels available to any litigant to challenge the award. So even though arbitration was supposed to be a quick process, you already have four layers of challenge available. Now, what happens is that if you don't allow a power of any power of modification, then the 34 court has only the option of setting aside the entire award, which in effect and practicality means that you go back and do a fresh arbitration. The reality of that sometimes means that a party is actually put to a lot more cost and actually has to face a larger delay in getting justice. And I think that was the underlying theme that the majority judgment has tried to address. They have, of course, limited the power to modify to, they have upheld that the power to set aside has the power to modify. So that was one big theoretical jurisprudential question which they have answered in the affirmative, which of course Justice Viswanathan has dissented from. But they have then said that, keeping in mind that the approach of the court should be one of restraint, they have limited the modification to only four different aspects. The first being that the court has the power to modify typographical and clerical errors. And to this extent, Justice Viswanathan has agreed with the majority and said that, on the basis of the principle that no act of the court should prejudice any litigant. Therefore, even if because the Arbitration Act has a power to correct awards under Section 33
itself.
Absolutely. So, and what they have said is that even assuming that correction is not done under Section 33, the Section 34 court or the Section 37 court is not precluded from this sort of clerical correction. One of the things that Justice Viswanathan has limited it to typographical and clerical. The majority uses the word manifest errors. Now, there is in paragraph 49. Now, this has the potential of becoming a slippery slope. So, you can use this word manifest error, and I'm sure people will, to say, to expand the scope of, what modification is possible. So this is one aspect which they have opined on. The second is that they have held that if the award is severable, then the invalid portion of the award may be set aside and the valid portion of the award may be upheld. Now, Justice Viswanathan has clearly confined it to the invalid portion being set aside. The majority, and I'm actually not sure what was meant in the majority when it comes to severance, because they have at one place in paragraph 45 said that you have the power to sever and modify the invalid portion. So whether the severance is confined only to setting aside the invalid portion, and vis-a-vis that, there can be a fresh arbitration, or only say claim 1 and 2 can be severed and set aside, and claims 3 and 4 can be upheld, or can you modify claims 1 and 2? So this is some aspect on which I think probably some clarity will be needed, and perhaps subsequent judgments will clarify that. But to the extent that severance is permitted, all 5 honorable judges have agreed on, and to the extent that the invalid portion of the award may be set aside and a valid portion may be upheld, again, all judges have taken the unanimous view that is possible, and that was also the position prior to this judgment coming in. At least the Delhi High Court had upheld that for quite a few years. The third thing which the majority has allowed, where there's a dissent by Justice Viswanathan, is the power to modify post-award interest. This is something that the majority has said that because as far as post-award interest is concerned, it is future-looking, and therefore the arbitral tribunal may not have the full sense of how the parties will choose to conduct themselves post the award, and therefore it's more appropriate if a court has the power to make that modification. Justice Viswanathan has disagreed with that and said that no, in such a situation, if the court feels that the quantum of interest is inappropriate, then it has the power to remand the matter back to the arbitral tribunal to cure this defect under Section 34, Clause 4, and it would not be appropriate to modify. So this is one aspect on which the majority and the minority are in complete disagreement. And the final aspect is the power under Article 142 of the Constitution, which was in any case, in many cases, was being used to modify at least questions of interest in the lead up to this decision as well. But the majority has found that there is in fact a power under Article 142 to do complete justice, for the Supreme Court to do complete justice. This power is of course not available to the Section 34 courts, which in many cases are the high courts. But they have held that as far as the Supreme Court is concerned, this power is available. The dissenting judgment has held that even under 142, to allow a modification under even Article 142 goes against the legislative scheme, and therefore no modification should be permissible even under this article of the Constitution. So this is broadly the areas on which the majority and the minority disagree. I think the dissenting judgment has taken a more puristic legal view on the issue and said that under our scheme, a modification is not possible. And the majority has taken a more practical, at some level, a more practical approach, and in the hope that this will actually reduce hardships. I also tend to, although I do believe a power of modification should be permissible. That's my own view, but I feel that it's best left to the legislature. There are certain jurisdictions that have allowed it, like Singapore and England and Australia and many others. But I still think it's a power that is best left to the legislature to sort of formulate the contours of. So that's
Thank you for the detailed opening comment. I'll go to Senior Advocate Arvind Nair for his opening comment. Over to you, Mr. Nair.
There isn't much to add after Justice Sikri and Tahira have explained the overview very articulately and in detail. But very quickly, Tarun, I just 3 or 4 aspects. See, eventually we have to see how the judgment plays on the ground. The positive from both the majority and the minorities, as Tahira also pointed out, I think the reasoning that is common to both opinions is that the reasons are that we want to preserve the purity of the arbitral process. That is the goal which both the majority and the minority judgment have said and have espoused, and rightly so, because we know, and in fact this was widely in the news recently, there is today a lot of concern in India about the arbitral timelines. That is in fact one major concern on the ground. In fact, you reported it, several other people also, it was widely reported. There are now several government departments who have done away with arbitration clauses. In fact, we are also aware from time to time, and this has become more frequent in recent, that even private companies who either do contractual work with government departments or even otherwise are doing away with the arbitration clauses. So this is a huge matter of concern. We can link this with the aspect of investor confidence. We can link this with the economy, the state of the economy, but it's a matter of concern. And I think that's what the logic has been. The majority, as Tahir again pointed out, the aspect of cost effectiveness and repeat arbitrations, that's one part of it. The other is that, as Justice Sikri said, and I'm sort of inclined to agree with that, I think on the ground nothing much is going to change. Net, it's going to be same, if I may use the pun. Because we have always, the way our judicial system is structured, Tarun, and this is all for the good because of the kind of judicial workload that we have, the sheer number of cases that our judges hear. We have a very large ingredient here is the concept of judicial discretion. And despite the limited contours given under Section 34, we have always had a huge element of judicial discretion when it comes to challenges to arbitral awards. I think what's going to happen is, on the ground, and I'm not going into which view is correct at the moment. That I think that we'll see when it plays on the ground in several other cases. There will be follow-up judgments. There are going to be interpretations. And my own view is that there is going to be some change by the legislature also. Because as I said, there is this outreach from the government also. We've had so many conferences that we wish to make India an arbitration hub. But there are matters of concern. I think the worry is what is now going to happen with judicial discretion there. We'll have to see how this plays on the ground. Are we going to have hearings where time is going to be taken to decide or to debate, or submissions are going to be advanced as to which part of the award is severable from the main award? What can you separate and what can you modify and what you can't separate? But I think the bottom line is, as I said, very necessary uh, plinth of our judicial system is the concept of equity. No matter what statute we may have, we have the Arbitration and Conciliation Act of 96, we have a much later Insolvency and Bankruptcy Code. These are all special statutes, but we've always had the concept of equity, and we've always had the system of reasoning and molding of relief. I think the kind of creativity that we often see from our honorable judges for molding the relief based on equity and justice and the bedrock of Article 14, perhaps we don't see in any other system. And I think perhaps this is where the majority opinion came from, that we must give that freedom to the courts to be able to, even if you agree with the reasoning, what is going to be the relief? I think it all eventually comes down to molding of the relief, and that is how it's going to play out. But as I said, the flip side is we don't want a situation where the element of judicial discretion in hearing challenges to arbitral awards, which is in any case a big factor, becomes more entrenched, because now we are going to have to, and of course the judges are all assisted by counsels, and lawyers now will be laboring. And the question is, will we have timelines? Perhaps the legislature may have to step in and say we are going to have more strict timelines insofar as lawyering in challenges to arbitral awards is concerned. I'm not saying about the judges who hear challenges, but the question is how much time is going to be taken in trying to show that this part of the award can be separated from the main award. That, I think, that's the concern. So I think it's still early days. Perhaps we'll have to wait for 6 months or a year or two to see. But the positive takeaway is majority opinion, minority opinion, both opinions want to say that we wish to preserve the purity of the arbitration process. And I think that's the goal, which the legislature is also working towards.
Point. Thank you for that opening comment. We have Senior Advocate Percival Bilimoria who joined us. Welcome on the show. Mr. Bilimoria, always you have some strong views on the subject of arbitration. When you have gone through this judgment, would like to know whether things have changed or they remain the same even after the passage of this judgment? Or do you think that as far as severance is concerned or modification is concerned, we will see some orders being passed to that effect after this judgment?
Hi, Tarun. Sorry for being a little late to the show. So, look, I tend to agree with the majority view on the panel that nothing much, as my friend Arvind said, net. Okay, that's a interesting term. I remember one of my former partners using that. So, overall, nothing much has changed. And as the judgment also itself explains, that there have been decisions which itself has been cited where rate of interest has been modified as being too excessive, or in fact, even the time period from which the interest would be levied, the commencing date, etc. So it has always been the situation, and I think this judgment only enables that. The interesting aspects, however, is that look, we follow UNCITRAL model, and the UNCITRAL model very clearly says set aside, right? Set aside an award. Now, set aside means annulment. Now, there is the Puritan view, the Puritan view of people who are strict purist, because that flows from the theory that, look, parties have elected to go to arbitration. So courts should not intervene. And, I agree that courts should not intervene, but practically, and that is the pragmatic view, if something is set aside, what is the option? Because the dispute still remains, right? So you've gone to arbitration. Now the award has been annulled by a Section 34 court, but the dispute still remains. So they would have to re-agitate the issue in another arbitration, and that was the more difficult point that I think we have to grapple with. I think we've spoken about that before. Again, the judgment suggests that, in certain situations, the court may intervene, but that is only Article 142, which is only Supreme Court. What about some of the 34 decisions go even to the civil courts, the district courts? So then what happens there? Does it mean that the district courts or the high court will not be able to modify? So that goes, it's in tandem with the general wisdom, which is that even if the courts have a different view compared to the tribunal, simply because you elected to go by what the tribunal says, the courts will not intervene and substitute its own view. So I think there is some dichotomy in these two stands, and I think while clarifying that yes, courts can legitimately intervene in certain limited cases as long as they do not go into the merits of the issue. So I think that boundary, has been very strictly laid out, and I think Justice K. Viswanathan has written a fantastic judgment. I think it's such a pleasure reading that, and I have to say that my opinion clearly was that in the interest of pragmatism, modification ought to be allowed. But after reading that decision, I'm somewhat ambivalent on the issue now, and I think that speaks volumes about his the
Scholarship.
the scholarship that he brings to bear.
Point very well taken. I'll get
I
Justice.
also said that look, I mean, when we go to the interpretation, I'll tend to agree with what Justice Vishwanathan has said. And as
Yeah.
Tahira also mentioned that yes, main, solution or is that the legislature steps in and make some amendment to Section 34. Yeah, sorry, yeah, Mr. Nangia, you wanted to say.
Two things I want you to reflect on for all the business community who's watching. They would want to sort of know uh, when we speak about severing the invalid portion award with the valid portion, that is again a very wide power. What is invalid to what is valid? Secondly, the special powers of Supreme Court under Article 142. To what extent they ought to be used, and will the courts themselves exercise restraint? Because in a growing economy like India, we see often disputes now are in the range of thousands of crores many times. So each dispute is in itself very important that lands up in the Supreme Court. So these two things, if you can reflect on for me.
Yeah, you see, if insofar as severance is concerned, I think it may not cause much problem. That was the position earlier as well. I tell you very simply, because as a power to set aside is there, but suppose the one portion of the award from second cannot be segregated or severed, then naturally entire award is to be set aside. I'm for time being, we are not going into the modification, etc., but the power to set aside the award. But then there may be some portion. Suppose one particular claim, and say I give you simple example. Suppose there is some misconduct on the part of the arbitral tribunal, or principles of natural justice are not followed. Then naturally award has to go in entirety. So it has to be set aside. But suppose there are 5, 7, 10 claims, and the claims are dependent on totally different provisions of the Contract Act which are decided. And the court finds that yes, out of 10 claims, 9 claims are rightly awarded, but one claim which is under that, it may be against public policy, or it is forbidden by law, or that particular clause of the contract says such a claim cannot be entertained, or like we have we have the principle of that accepted matters, so it was not arbitrable at all. So then it could be, there's no reason or no, justification in setting aside the entire award. So only to that extent, that particular claim, the court separates it from the rest of the award and say that this is set aside. So therefore, principle of severability is really a welcome move, which was earlier also exercised. And as Percy also has said, that the position is now clarified and it is given in a legal sanction by five-judge bench judgment. So therefore, there would not be the debate on this would now get quietened. That it will not be. Suppose one claim is severed and set aside, the other party, losing party, may not go and say no, the court should have set aside the entire award, etc. So that goes, and that in any case is, I think best position, not only in practical term, which is legally also permissible, and it is good for the business, that instead of then having all 10 claims agitated together, so only one or two claims are set aside, and on other the awards is upheld. That is one aspect insofar as this is concerned. Coming to on modification, etc., what Mr. Arvind Nayyar has said, and I will agree with him on that. Look, and let us see in next 6 months, 8 months, or 1 year what happens, because uh, I have 3 lawyers before me, and you are also general counsel, but the ingenuity of lawyers is unbound. So from this only they would be, tomorrow debates would be that whether it comes within the power of modification, it doesn't come within the power of modification, so this is wrong, it should be modified, it should not be modified. So another debate would start. So whether we are inching towards the speedy disposal of the cases of section 2034, or yes, to that extent, majority opinion is more practical, as we say that instead of sending it back, court is doing now itself. But then before court does that, the court will face with many kinds of issues which the lawyers will now bring, and whether it would be, as I said, it is capable of modification, it is not capable of modification, because there can be so many situations which will crop up, which may not be before the court when this five-judge bench judgment was given. So all those situations, particular situations, when they come up and the debates are on that, and then the courts are struggling whether, yes, power to modify should be exercised in this circumstance or it should not be exercised. So this is, is yet to be tested. So as Arvind said, and I am quite agreeing with it. Coming to your 142, of course, there have been always, the law is very clear on that. That 142, because this power under Article 142 is conferred only on the Supreme Court. And the purpose is to, in order to do complete justice in the matter. First of all, now question arises is, yes, to do complete justice in the matter, whether in the arbitrations, when these are there, that because whenever there is say discretionary powers or power to be exercised in equity, etc., is a different thing, and 142 exercised. But here, section 28, subsection 2 very categorically states that equity has no role to play. It's only contractually, if there are rights in favor of one party, those will be granted. If there are no rights, those will be, no relief will be granted by the arbitral tribunal on the basis of equity. Equity is also a well-established branch of law, but that can't be touched upon as well as unless the parties themselves agree, which normally doesn't happen. And another thing is that while defining the limits of Article 42, Supreme Court has said many times, yes, in order to do complete justice, but that should not be against any provisions of law, any statutory provision. That doesn't mean while exercising 142, the Supreme Court is itself violating some provisions of law. But having said that, in given circumstances, many times such power is exercised, even in those cases, and therefore it has come under criticism. So the judgments of the Supreme Court under 142 are itself, subject matter of very great debate or deal. No doubt the majority, while saying that, and that's why Justice Viswanathan says there's no question of 142 at all. And but the majority says no, under certain circumstances we can, as I've just said, coming to rate of interest, etc., 142 can be exercised. And Percy has rightly mentioned whether, if that can be exercised, whether it is only the Supreme Court which can do, or 34 court and 37 court can also do it. Because on one hand, the impression given is no power to because power to modify is under Section 32, not when the matter is only pending before Supreme Court. Supreme Court has additional power, 32 plus Article 142. But then 142 again is, I mean, something, of course, 142 power will be exercised only by the Supreme Court. It can't be exercised by the subordinate courts. And I hope that it will be exercised, which the majority has also said, only in extreme cases, to really to avoid a real hardship which may be caused otherwise.
Thanks for sort of clearing that air, because for people investing in India, these things hold of great importance. They need clarity on these issues, and there is indeed a great deal of confusion. Hope what you have shared will help clear their doubts of the investing community. I'll go to Advocate Tahira Karanjawala. My question to you would be, so if the court in its wisdom decides to reduce the interest rates awarded in the arbitral award, would that be amounting to modification of the award? And given the crazy timelines of court litigation in India, where the arbitral award may be of 2009, adjudicated by Supreme Court in 2025, when there is a 15-year time delay, the interest cost in many cases may be more than the award cost, as we have seen in some cases. If that be true, would reduction in interest rate amount to modification or justice and fair play? How would you look at it?
Thank you, Tarun. So just to clarify, the Supreme Court majority judgment has only allowed a modification of post-award interest. Pre-award interest is still something that is the domain of the arbitrator, from my understanding of the judgment, as is the date from which the interest will be granted. See, of course, the power to reduce the rate of interest is a powerful one, certainly. But at a practical level, I think it is okay to leave it to the courts. Again, in my view, it's better if these provisions had been spelled out by the legislature as opposed to having read the power into the provision. However, on the whole, I think there is nothing wrong with allowing the courts to modify the rate of interest, given, sometimes, as you rightly pointed out, in certain cases you have, monthly compounded, and the interest can become, 10 times the actual principal sum. So in this kind of a situation, allowing the courts to have the power to reduce is also, according to me, in the overall interests of justice and in the fairness of things, to be absolutely honest with you. But again, I think that it would have, frankly, I think that the power to modify interest should also apply to pre-award interest. I don't see why it should only apply to post-award interest, but this is a power that should have been conferred legislatively, and not necessarily because they were reading in, they have confined it to only post-award interest, because it's something which the Act provides a certain interest rate if the arbitral award is silent on it. And it was that reasoning which was used by the majority judgment. But I mean, I think that it's pointless to have so many layers of appeal without having the court ability to, sort of mold that relief, given that sometimes the entire adjudication of a matter can go up to 10 years. It's, I think, in the interest of things to allow that power of modification. Well,
Yeah, because in India, conditions are very peculiar. The arbitration tribunal, in a sense, may deliver its award in 2 years. But if it takes 10 years in courts, I'll go to Senior Advocate Arvind Nair, who can reflect on this very issue. What about Section 34, 37 and Supreme Court? Between that, if 8-9 years pass away, is it fair that the courts have this power that they reduce, and would it amount to modification of the award if they reduce the interest rate, which is post-award interest, as also Tahira clarified?
No, that's what I said. Tarun, just to answer that, that's what I said. What is common to both the majority and the minority opinion is that everybody wants to maintain the purity of the arbitral process. Today, the biggest concern, as you rightly said, is the time taken. Now, as I said, the legislature has, there are restrictions. You finish it in 1 year and then take an extension. But then how do you curtail? And I hope this doesn't come back to bite me. How do you curtail the ingenuity of lawyers and counsels? I think if there has to be any legislative intent, perhaps there may have to be some restriction on how long you can take to make submissions. I don't know. I'm just sort of throwing it in the air. We have Justice Sikri here, and he can probably better reflect on this, or my colleagues, as to whether any sort of restriction can be placed on how much you can make, how much you can challenge these awards. Because if you are if you're not able to execute an award within, and I'm the peculiarity of the Indian system, the sheer workload, if you can't do it within 5 years, then no matter what we say, no matter what ordinances we have, what rules we have, what amendments we have, I don't think we are going to have confidence on the ground level in the arbitration process as an alternative dispute mechanism. Then it's merely an extra layer. So I think that judicial discretion we've always had, eventually it all boils down to molding of the relief, as Tahira said. Just to give you an example from this original case, Gayatri Balasamy versus ISG Novasoft. The controversy was two private executives came to the Supreme Court for a dispute. The Supreme Court referred them to arbitration. The arbitral tribunal awarded 2 crores to one party as damages. Matter went up under, in Section 34, challenge before the single judge. The single judge said everything's okay, but I am adding 1.6 crore to the 2 crore that was given. So from 2 crore, 1.6 crore gets added. Then the matter goes to the Honorable Division Bench, who says everything is fine, the reasoning is all right, but this 1.6 crore is excessive. We are going to reduce it to 50,000.
50,000
to 50,000. So now that's what I'm saying. The bottom line is we have to decide where this process has to go. And I think it's a larger issue. All stakeholders have to decide: lawyers, our firms, councils, our honorable judges, of course, our luminaries like Justice Sikri, the legislature. Eventually, it has to be decided at that level that how do we want to take this process forward? Is it going to be, at the end of the day, one more system which is going to take 10 years? Because here, I think the country, the nation as a whole, perhaps there are repercussions. If for instance, just to, not saying that an individual's litigation is any less important, but if there is a partition suit between siblings and it takes very long, it's only those 6 or 8 people or 4 people, or as the case may be, who are affected. But if there is an arbitral process that begins with proceedings before an arbitral tribunal, and it's going to take 10 years or 15 years to conclude, there are repercussions, as you yourself said, about investor confidence, about economics, about there are other aspects to it. What are various other institutions going to take? We have, all of us have a dream who do some work on the arbitration side, that we must take India to a height which sort of matches or exceeds places like Singapore, London, Dubai. But the question is, we all have to decide as stakeholders. I think this is a step forward, and like I said, I have great faith in the element of judicial discretion that is
Yes.
exercised by our honorable judges and also by our honorable arbitrators.
Thank you for that. Thank you for that intervention. I'll go to Senior Advocate Percival Billimoria, who will also address on these 3 issues: modification, Article 142, and severance. What part to be severed from the award, and the impact of that, and how will, in his view, the courts look at all of this?
So severance makes sense. So let's put it very simply in layman terms. Suppose there are 3 different claims. Now the court says that, look, I have difficulty with one of the claims, the decision on one of the claims, right? So the only question is that, is there anything pertaining to that claim where the court has a problem? And is that interlinked with the decision on the other claim? Because if there is a common thread running through most of the case, and it's been divided into 3 claims just for the sake of presenting it better. But there can be situations where the 3 claims are completely independent of each other. So the question is that, can you just sever this and say, okay, this one is something that the court will focus on? So that severance issue And as Tahira mentioned, it already been decided by the Delhi High Court in an excellent judgment. But coming to the real crux, Tarun, see, I have often said that, look, why do people go to arbitration? One is it's supposed to be cheaper. I don't think anybody now agrees that international arbitration is very much cheaper than, in fact, it's for anything more expensive. Secondly, time. Given the fact that our courts are, have a huge backlog now, time may be a big issue. But at the end of the day, see, you keep talking about businessmen, right, or foreign investors. At the end of the day, foreign investors or businessmen also need the assurance that, look, whatever judicial process that you follow or extrajudicial process that you follow, dispute resolution process, you will ultimately end up with a result that you are fairly comfortable with. I mean, you may not, no litigant is always happy when they lose a court battle or a arbitration award when they are on the wrong end of the award. But at the end of the day, if he can walk away and say, okay, you know what, I think, on second thought, that was a good, a fair result, right? That is what is also important. And I think this is where, this judgment goes to a little further extent than previously. And I'll just read, the key paras in the majority opinion are 40 to 42. And I'll just read this. It says that judicial intervention is legitimate. Okay, judicial intervention is legitimate and necessary. Right? I mean, previously we always said that courts have a supervisory jurisdiction, and Section 5 of the Act also says that courts should not have an interventionist approach. Now, to my mind, this is a little different. It says judicial intervention is legitimate and necessary when it furthers the end of justice. Right. And I tend to agree with that sentiment, because if you have an award that needs to be interfered with, it has to be interfered. Right. And I think the only way to resolve that, Tarun, is please ensure that tribunals have some mechanism where they come up with a decent award where the litigants feel comfortable, even if they lose. This is a key issue, right? You can't just say that, look, you have elected arbitration, so you may not be happy. It may even be unfair, right? But you will just have to live with it. That, I don't think that encourages a business situation, right? And this is something that we must realize. So, look, institutional arbitration, and there's an amendment act which is on the table. Institutional arbitration does go a long way to resolve that, whether it is foreign institutions or Indian institution, because they have mechanisms such as peer reviews. Some of our institutions have not yet built that into the framework, but foreign institutions do have a mechanism of a peer review, for example, right? So unless this kind of a framework emerges even with Indian institutions, you do run a huge risk that simply because you have opted for arbitration, even if you suffer an award which is, in your view, patently illegal, you'll just have to lump it. Again, that I think is contrary to the three aims of arbitration, which is speedy justice, timely justice, and correct justice also. That is also an aim. And I don't think that judicially we have paid enough attention to this issue, which now, in my view, changes. And then just see what 42 says. If we were to decide that courts can only set aside and not modify, parties would be compelled to undergo an extra round of arbitration, which is what I was mentioning earlier, that, okay, the award has been set aside. And if that's the way you read it, right, then there'll be a further round of litigation. So what does that do to your other two objectives of cost and timely disposal of the matter?
Yes.
Right. So I think I don't think it is just interest. So, for example, if you have a situation where you are challenging the award on the fairness of procedure,
Yes.
leave alone on merit. You're not questioning the award on merit. You're questioning on fairness of procedure. I would like to believe that we would be capable of using this to say, look, the procedure has not been fair.
Point well taken. Point well taken. A very passionately spoken, Mr. Bilimore, as always. I'll go to Justice Sajjan Kumar Sikri. So whenever I speak to businessmen and promoters, they say, Tarun, arbitration is an idea in India whose time has come. There can be roadblocks, but you see this will only grow in future because this is what the industry wants. They want ADR, and quick disposal will happen only through arbitration. In fact, I am privy to certain cases where companies hinge whether they want to invest in India basis whether they do get the option to arbitrate or no. If they don't get, they will not invest. So that is why arbitration is an idea where the industry will give push. What do you think the courts, in your final comment, ought to do to encourage this, in a sense, environment? And also in your final comment, see, we have a lot of judges doing arbitration. In India, judges don't get to work till 85 like in other courts in America, and also it is natural that they'll continue to work even in the later years. So most of the judges adjudicating in Supreme Court today, we may see them doing arbitration, even on this bench who gave this judgment. So they are conscious that this is something that they may end up doing in future, and they are conscious of this situation. Not all, but at least a large portion of them. Given that as a fact, where are we headed, and in what direction is this judgment taking us, as your final comment?
You see, as far as your first comment is concerned, and that is what the business community wants and international business community wants also, that yes, arbitration, it may suffer from some of the maladies, some reforms may be needed in the ecosystem. But all said and done, arbitration is not only here to stay, it is here to grow. And it is more so when the courts are already clogged and heavily burdened with the arrears and backlog. So therefore, as you mentioned, that the business community wants their disputes to be resolved as quickly as possible. One very, very important aspect is that, look, many times when there is some kind of say contractual relationship between the parties, and but some disputes arise, they still want to continue with that. Suppose they have, the contractual relationship has not come to an end, but they want the disputes to be resolved but maintain the contractual relationship. In this scenario, arbitration is always better than the court proceedings because of its confidentiality. Because we have section 42A of in the Arbitration Act, and it is a worldwide recognized concept or principle that unless the parties themselves want it to be made public, the arbitration proceedings are confidential. So whatever is happening, they don't want even some little dirt which has come in the relationship, that dirty linen or that part of the linen is washed in the public. So let it be decided here, in the arbitration, through arbitration. So that is one very, very important factor insofar as the business community is concerned. Apart from, yes, cost and speed, etc., which are there, and even today, in comparison with the court system, the arbitration system, at least till the time award is given, it plays very fast. That also because of section 29A of the Act, which has a limitation of 1 year to decide the award, 6 months for pleadings and 1 year. 6 months the parties can extend, so it may go up to 2 years, thereafter only the court. And it has always been a desire, at least I would like, that in my case, in which I am the arbitrator, the situation should not come that the parties have to go to the court. Sometimes you can't help it, but my endeavor is always like that. So therefore, we try to finish it within this time frame. Yes, again, when it comes to enforcement, and as everybody has said, then again it gets stuck in the court, but that is court. At least still there's another saving or factor and another positive here also, even if it is stuck for as far as enforcement is concerned, because award is a decree. It is challenged under section 34, but then now section 36 is amended and there is no automatic stay. And normally the courts are granting stay subject to deposit of the amount. So the party which has won is able to get the fruit even when the challenge is pending, maybe subject to bank guarantee or some other terms. At least they are able to see the color of money. So it's not that if it is stuck in the system for 5 years. So that is another factor in favor of the arbitration, and the business community would welcome that. Okay, after the award has come, we will have some 25%, 50%, 75%, and maybe 100% of that amount with us, money with us today in our hands. And so these are some of the factors because of which the arbitration, yes, as I have said, it has its own, I mean, at the same time, the people are struggling on so many aspects, and the arbitration, as I mean, Percy has also mentioned rightly so, the today international arbitration is not what we call cheap or cost effective. It is not at all. And the costs involved are much high. And but it is, I'll only add one thing, it is not only because arbitrators are charging high, but the lawyers are charging maybe 3 or 4 times what the arbitrators are able to get. So therefore, cost, when it is a cost to the litigant, cost is and much more to the lawyers and other costs which they have to pay, but you can't help it. And yes, there should be some, I mean, measures taken to reduce these costs, etc. But reforms is one thing. Yeah, we should bring the reforms, but we can't do away with the arbitration. So it is here to stay at it is. The other thing which I'll say now, coming back to this again, judgment on the basis of which you have asked me the second question, what I feel is, and from what we have discussed today, you see, interestingly, we are at a stage where amendment bill is already pending insofar as Arbitration Act is concerned. It is already there. It is almost at the advanced stage where the discussions, etc., are taking place, and it may be introduced in the parliament soon. And let us see, it depends on the will of the government when it is introduced and when legislature pass. But while doing so, now in view of this judgment and going by the pros and cons of this judgment, and it is to be given some legislative mandate of what the court has done, whether majority or, so this is a very good occasion even for the legislature to step in and make it more sanctified.
Point very well. Thank you for this closing comment. Really happy to do this show today. A very constructive discussion on this good judgment. The only takeaway that I also see is that when I speak to companies, they say we love to invest money in India, allow us arbitration. This is what they expect of the government. And these are really big companies. These are one of the world's biggest companies who can put serious money into this country. The only thing they need is the opportunity at ADR, which I think we must give them. But that topic we'll discuss on another show. I'd like to thank Justice Sikri for his time, Tahira Karanjawala from Karanjawala and Company, Senior Advocate Percival Bilimoria, Senior Advocate Arvind Nair. Appreciate your joining on this very important issue, on this very important judgment. And of course, we'll continue this conversation. But that's it for now. Thank you so very much.
Thanks, sir.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.